Welcome everyone. Jared Ambeau here, owner of the Ambeau Law Firm and founder of Trial Alliance. And today's topic for the issue number 31 is being prepared. Well, what does that mean? So I have a lot of stuff going on right now. It's a very busy time of year in the criminal defense practice, and every lawyer I talk to right now is like, man, I'm just inundated. I love it, 100% love it. I mean, we're just busy, we're going and going, and I dig that time for sure. We've got a very big second-degree murder trial starting next week that we've been preparing for a very long time. We are very prepared for that. I had a hearing this morning, an administrative law hearing this morning, and this afternoon at 1:30 I'm going to the State Police Crime Lab for a visit on another second-degree murder in another parish where I'm doing some work for another attorney. And what comes to mind today for me is preparation. Am I prepared? Am I prepared to go to trial? Check. Was I prepared for the hearing this morning? Check. Am I prepared to assist in this case, this second-degree murder case in another parish? Check. I am, and I know I am. I know how that feels. I know what that looks like. I understand today what that looks like. So there's a significant, in my trial next week, there's not any forensic science to be spoken of, but in this other trial, there's a tremendous amount of forensic science evidence and a tremendous amount of DNA evidence, which is what I'm doing in the case. And in previous years, 3, 5, 7, 10 years ago, when I first started practicing, and during the time where I didn't have the forensic science information, I wasn't real sure about what to do. You would get DNA, I'd get DNA evidence, and I'd read it and be like, oh man, those are huge numbers. What do I do with that? Of course, being the person that I am, I didn't just take it at face value, right? That wasn't prepared enough for me, for my taste, right? That to me wasn't sufficient. So I began to look, and I began to question, well, what do these numbers mean? What does this match thing mean? What is this statistic? Where are they deriving these numbers, right? And I had a sense about it then that something seemed wrong or amiss, right? That the numbers were massive, 1 in quintillions, right? Zeros and zeros followed by zeros and zeros, literally more human beings than will ever exist on the earth. And so I thought, well, then how is that the calculation? That just doesn't even make any sense, right? I mean, I've since understood now that that's not what I thought it was at the time, but my point was that I didn't just take it at face value, right? Because I had to go to trial in these issues, I had to be prepared. And part of that preparation was seeking the right information from the right persons and from the right sources. And so that's what's going on with me today. I went into that Division of Administrative Law hearing today with all of my jury trial experience, and I began to talk about the code of evidence, right? Made an objection as to foundation. Everybody looked at me like I was crazy, so I explained what I was doing, right? The objection is based on the fact that the opposing counsel has not laid a proper foundation. He hasn't developed the kind of information necessary from this witness to show that this witness is capable of answering the question he just asked in a way that's reliable and admissible in this court. Before he asks the kind of question he just asks, he has to establish that this witness is the person that can answer that question. And so he has to lay a foundation as to that question. And so I objected. As a judge, I understand the rules of evidence don't apply strictly here, but still a point to the rules of evidence, and those underlying precepts mean something, and they're important, and let's talk about why they mean something and why I think it's applicable in this particular situation. And I talked about hearsay within hearsay and the reliability of those statements and the fact that the hearsay rule is in place because it measures reliability, right? The codified hearsay rules in place because it measures reliability. The Sixth Amendment right is about confrontation, but I was talking about the reliability of statements, and so we talked about that and what reliability meant and why hearsay within hearsay is even worse because then it's even attenuated even more, right? And so this is good information to have. I know this because I've read the Code of Evidence over and over and over and over again. Every trial I go to, I have flashcards. I have Code of Evidence flashcards that I go through to make sure that I know exactly what it is. It's my toolbox. This is the preparation information that is important for me in those situations. And so in any of these places that I go to, in any of these matters I enter into, how am I preparing? What am I willing to do? And what energy am I putting into the situation so that I can extract everything I need to from it, right? From this visit to the State Police Crime Lab. Well, why am I prepared to do that? Because I'm in my last semester of a master's degree in forensic DNA. So I know I know what I'm looking for. I know the information I'm going there to receive. I have a list of things that I'm looking for that I need to take, examine, copy, and bring back to the office so that I can disseminate that to the other attorney, and we can talk about how those things are useful. And so that's what I'm looking for. I know because I went to the information. I went and got the education. I read the books. I know what these motions are about. I know why to file these motions. I know what substance I'm looking for, but it's more than just a checkbox, right? It's more than just a list. I understand why I want maintenance records. Because if the maintenance records aren't there, then how reliable is the machine? I know why I want the quantification information and data from the DNA. Why? Because it's important. It's important as to the case, as to what's the starting quantity of DNA in this analysis, right? And so these are the kind of things that I ask myself often. Am I prepared? Do I know what I'm looking for? Is my knowledge of this, is it on the surface? Is it, I know I'm looking for these 5 things? Or is it further than that? Why am I looking for these 5 things? And then the next level, not only why am I looking for those things, but how does this why fit into my case and into my interest, right? Or into what I'm looking for. So what's the context of that why, right? So I'm looking for, background data. Well, I'm looking for background data because I want information about quantitation, because I think that's important in this particular case. Well, why? Because in the context, this is a very low template sample of DNA. And so I need to know how low. And it's supposedly a mixture between a male and a female. So I need to know the nature of that mixture and how much of it was male DNA and how much of it was female DNA. And I can extract all that information from the data. So I need the data, right? And I need to know what context it's in and how it's in there. So my question today is, am I prepared? Am I prepared to do the things I have to do? And am I prepared in a way that has substance and has depth? Am I not just prepared on the surface, but do I understand what I'm doing in the context with which I'm doing it? As I prepare for this murder trial next week, and I say, well, I'm prepared. Well, what does that mean? Well, I've got all my files labeled in a spot. Well, that's not prepared. That's just organized, right? Well, now I know what every one of these segments are made. Okay, great. So you know what's happening. Well, so this witness made 4 statements. Okay, great. That's a little more prepared. Well, you know that they were inconsistent in particular moments. Oh, that's a little more prepared. When you know they were inconsistent as to this subject at this time, and this is how that fits in the context of your theory of the case. Now we're getting somewhere, right? That's another layer of being prepared, right? Well, you know that in the way that you cross-examine, that at this point in the cross-examination is the best place to elicit this testimony, because it fits into the structure of the cross-examination, the chapters that I'm trying to get to. Now we're really getting somewhere, right? Now things are really starting to add up, right? Because the way that I've chaptered this cross-examination tells a bigger story, right? And makes the cross-examination itself and the chapters of those cross-examination fit into the theory of my case in a way that's meaningful. And so that's why, now I'm 4, 5, 6, 7 layers in. That's real preparation. That's what actual preparation looks like. That's not winging it. That's not hitting it in hope. That's knowing where I'm going. That's knowing where I am and where I'm going. And that, to me, is a big part of preparation. That, to me, is what it really looks like to be prepared to try a case. And that's where I'm at today. So anyway, I appreciate you guys coming by. Thank you very much for listening, and I will see you all tomorrow.